Hello, ladies and gentlemen. One more time from Jeff Goldtrap's office, 615-254-1471. If you need me, give me a call. Today, I'm going to bring you more edification, information, and knowledge. And today's subject is bond. We talked about the factors, the recipe, the points that a judge must consider when setting a bond or when, as I hope to, reducing a bond to something that my client can make and get out on the street. We talked about 5 different factors, and now we're going to talk about some more. Another factor that the judge must consider is point number 6, factor number 6, the nature of the offense and the apparent probability of conviction. This is something that mostly you hear the state of Tennessee raising. The district attorney, the prosecutor, they'll say, Judge, when you consider the bond, you should consider the allegations. Now, these are just charges. You're not convicted of anything. But they should say, Judge, we have a person that Mr. Goldtrap just beat to a bloody pulp, and he beat him on the sidewalk at, Dedrick Street and 4th Avenue, and it was in the middle of day at lunch hour when everybody from all the offices buildings were out there, and we've got 300 people that saw it and are signed on as witnesses to this case. Well, the judge might say, the nature of the offense, a personal assault, the nature of the offense, maybe the person was put into the hospital and injured. The apparent likelihood of conviction, we've got this huge number of witnesses. Maybe we've got a victim who can recount specifically and say, that's the guy that did this to me. Maybe they might have DNA evidence from scientific tests, weapons, all these things. They're going to bring that out. And the judge is going to consider these things not as whether you did or didn't do the charge, okay? Not whether you're guilty or innocent, but what is the likelihood of conviction. Now, you do the same thing when you're trying to buy, let's say you're buying a car. You're going to think about what's the likelihood that this car is going to take me through this year and into next year and maybe into the next several years. And if you go to look at a car and the car has got, you open the hood and the car's got no engine. Now you'd say, well, the likelihood of this being a good buy is 0. Well, the judge looks at the likelihood of conviction and says, what are the chances that the state will be able to carry their day? Then the judge must think about what's the likely outcome from that. Is this a charge that you're likely to go to prison for a long time? You might have more motivation for not appearing in court. Anyway, the judge must consider the nature of the offense, the apparent probability of a conviction, and the likely sentence. The judge must also consider, point number 7, the defendant's prior criminal record and the likelihood that because of the record, the offender will pose a risk to the community. This is, again, what the state always brings up. Judge, you should consider the record of Mr. Goldtrap. He not only is charged with aggravated assault, but if you look at his record, since he was a wee little tot of only 18 years old, he has committed an aggravated assault every year since now. Believe me, if you know me, you know that's not me. This is all make-believe. But if I bring to the judge and say, I want a reduction in bond for my client, and my client has a lengthy record, think for yourself, what are the chances that the judge is going to hear me and say, yes, Jeff, I agree? Well, the chances are not good. But it's a factor that the judge must consider, the length of record of the defendant. Finally, the identity of responsible members of the community who will vouch for the person's reliability, the likelihood that they will come to court. Your employer, friends, family, neighbors, people who can say, if this person, if Jeff, for example, says he's going to do something, then by George, he's going to do it. Finally, any other factors that the judge should consider. This is kind of a catch-all that I can bring in. So what have we learned? In considering bond, other factors are going to be your prior criminal record, whether that tells us that you are a danger to the community, whether that tells us that you will appear in court, the likely sentence, what motivation do you have for not appearing in court, And who are some people that will come and say, Jeff is a guy that you judge that you can rely on. Factors to consider in setting bond. If your bond is too high, give me a call. Let's file a motion to reduce bond. Have a great day.